As LDAs, we've set up our businesses and systems to help many self-represented customers and to earn money providing form preparation services. In fact, sometimes we think to ourselves, the more customers we get, the better. But in today's podcast, we're going to talk about in what situation should you consider not working with a self-represented litigant. I'm sharing this with you because in my 8 years of LDA experience working with the public, I have identified 3 types of self-represented litigants that LDAs may mean that they might not be able to help. The first type is the potential customer that needs an attorney. The second is the potential customer who can't afford to pay any type of fee. And the third, the customer whose scope of work has changed since you first signed a contract for services. I'm hoping that by me sharing these 3 customer types, you'll be able to identify them and be better to able guide them and give them a professional referral to someone who can help them. The most common type is the potential customer that needs an attorney. Here are a few telltale signs that this customer calling you might need an attorney. They need legal advice. They don't understand their rights, obligations, and need legal recommendation, strategy, or opinions regarding their specific situation in their case. Given that LDAs assist with form preparation, court filings, and providing legal information either published or approved by an attorney, LDAs cannot help self-represented litigants if these individuals need an attorney. In fact, per BPC Code Section 6401.6, a legal document assistant may not provide service to a customer who requires assistance that exceeds the definition of self-help service and shall inform the customer that the customer requires the services of an attorney. Another way to tell if a self-represented litigant needs an attorney is if the individual has an upcoming court hearing, mediation, or trial. Most of the time, these individuals need attorney representation, a service that LDAs cannot provide. And of course, many cases that require an attorney are usually because the case issues are various and they are complex and they require legal advice and recommendations from an attorney. These persons' cases may require more than just form preparation, court filings, or legal information. When the self-represented litigant needs an attorney, the LDA can refer them to their local bar association or give the individual a list of LDA-friendly private attorneys that they can reach out to directly. Next, let's talk about another potential customer that you might have to consider also referring to an alternate resource. Specifically, let's talk about the potential customer that can't afford to pay any fees. Sometimes customers will reach out to you inquiring about your services, and when you quote them, they let you know that they aren't able to afford any fees. There can be many reasons why someone can't afford LDA fees. Perhaps this individual hasn't been working, or they've been laid off from their job, or perhaps their household monthly expenses exceed their income. In these situations, the LDA can refer the potential customer to either the law facilitator's office in the nearest courthouse to assist them with legal help, such as with filing their case for free or helping them fill out their paperwork. The LDA can give the potential customer the contact information and the referral's address. In addition, the LDA can make it a point to let these potential customers know that a request to waive court fees may be an option in their case so that they may apply to have either their fees waived at the court or request that the court allow payment plans of the filing fee for their case. Sometimes filling out a fee waiver alone is what these individuals need to get their case started working with an LDA. In my experience, if the customer has difficulty paying your initial fees, they may have difficulty paying the remaining balance, and in these situations, it's best for the LDA to refer the individual to the facilitator's office or a legal aid clinic so that they may receive the free help that they need. So far, we've talked about potential customers that you identify on day 1 that you might not be able to help. Potential customers like those that need an attorney or those that can't afford to pay any fees. But what about those customers that signed a contract with the LDA to perform form preparation services, but that the scope of the work that was initially contracted for has changed? So for example, in the case of a divorce, the customer perhaps contacted the LDA and said that they were in agreement with the terms of the divorce with their spouse and that both parties were cooperating, and that there were no legal issues of property to be divided or spousal support to be paid or received. And with that information, the LDA signed the notice to consumer and contracted with the customer, where the scope of the work was clearly laid out. And now the LDA has been working with the customer for a few weeks or months, and all of a sudden the LDA starts to identify certain issues that may require that the LDA refer the customer out to an attorney to seek legal advice, as discussed earlier on this podcast. Specifically, these are the types of customers that initially started as the perfect LDA customer, but as the case progressed, the needs were more than just form preparation, court filings, or access to information, either published or approved by an attorney. If in the course of the LDA providing services, the needs of the customers have changed, or the LDA identified that the customer has omitted information, was not truthful, or outright lied about the circumstances regarding the individual's case, or if the case got contested, or maybe one party is no longer cooperating, the LDA may not be able to continue assisting the customer, especially if the LDA doesn't feel comfortable. In these situations, the LDA may want to communicate to the customer as soon as possible when the LDA identifies that the scope of the work for which the LDA was contracted for has changed and is outside the scope of what an LDA can do. Telling the customer in a timely manner that the LDA will no longer be able to assist will allow the potential customer to find a resource that they need in order to continue to represent themselves in their case and to avoid any delays or issues. For these type of customers, it's okay for the LDA to refer them to an attorney or to the law facilitator's office or legal aid clinic. Just because the LDA started the case or had some involvement doesn't necessarily mean that the LDA has to be the person to finish the case, especially if the LDA is not feeling comfortable or safe, like in situations where a restraining order has been placed against one party. It's okay to refer the customer to the Bar Association, the facilitator's office, or an LDA-friendly attorney contact so that the customer may seek the appropriate professional services that they require. To recap, these are the 3 types of customers that you may consider referring out. The first type is the potential customer that needs an attorney. The second is the potential customer who can't afford to pay any type of fee. And the third is the customer whose scope of work has changed since you first signed the contract for services. Thanks for listening. If you like the podcast, please hit like and consider subscribing. Thank you.